You found my name in the rain on the porch. I kept it small like a pin in a glove. Your shadow leaned on the apple crate step, and the clock in the hall would not answer us. Stay a little while, stay a little near. Your breath on my cheek like a borrowed fear. Dance me slow, paper moon lace. Hold my hand in a stranger place. Hold my hand, sweet and still we could disappear. Dance me slow and leave me here. Your collar was white, but your eyes were bold, like a key in a jar with a secret hold. I heard the boards count softly our feet, and the room grew thin as a candle leaf. Stay a little while, stay a little near. Your breath on my cheek like a borrowed fear. Dance me slow, paper moon lace. Hold my hand in a stranger place. Hold my hand, sweet and still we could disappear. Dance me slow and leave me here.
Good morning, everybody. How are you? I hope everybody is doing well. Good morning, Karen. Good morning, Chicken Lady. Esther's surgery is scheduled for July 16th. We drop her off July 15th, though. Prayers definitely welcomed. I got my fingers crossed. I'm sending all the juju to you and to Esther. I hope everything works out fantastically and she's a happy, healthy little goat. Hey, Mally, good to see you. Nicole Be Cool, what's up? Hey, Jonah's mom. My cousin is happy that there is a live today. He says, I'm happier when I'm spending time with the ward. Well, thank you to your cousin. Appreciate him or her. Him. Yeah, he says. Okay. Geez, Jen, context clues. Durr. I'm glad he's watching. Thank you. Hey, Allie G. Hey, Neat Noodle. Good morning. Let's see. Good morning, everyone. Good to see you guys. All right, so we're going to watch it's a scheduling hearing. But prior to the scheduling hearing, the defense had filed a bunch of motions that they're going to talk about during the hearing. I wanted to go. I went to find them, and then I realized after reading what the motions were, I didn't read the motions themselves, just reading what the motions were, that they talk about it during this hearing. So I was like, well, why am I gonna, bore you guys reading, especially since yesterday, golly, if you guys missed that live, last night I went over the new DNA testing update from regarding the West Memphis 3. The testing, they say the results should be out by the end of July. So I'm anxiously waiting for those. But I was apparently aboard the struggle bus yesterday with an all-day pass, and I'm thinking that, quite frankly, I think that pass has been extended for the rest of the week at this point, because it is what it is. So yeah, Jonah's mom says, therapy couldn't have gone better this morning. I walked twice and it felt natural. Oh, that's amazing. Yay. I'm so happy for you, babe. So happy. Yeah, so yesterday was a struggle. And so I thought today, well, if yesterday's a struggle, today seems struggle-ish. So probably better not for me not to read. I'll just try to speak, which clearly is also an issue for me today. So we'll just get through it, okay? All right. Let me share my screen. As you can see on your screen here, the Poot is in the building, and he's going to be making, can't get comfortable in this chair. He's going to be making the majority of the arguments today. So we're going to listen in, talk about what's what. I have the closed captions on. I was going to speed it up, but I'm not going to. All right, here we go. There's Jim Griffin together with Dick Harpootlian. They are the Statler and Waldorf of the South, to me, with a little Foghorn Leghorn mixed in. That's just how I see them. Let's see. Let's actually get to the hearing. Let's get to the meat and potatoes. Still no meat and potatoes. Also, no more meat. No meat.
Of your counsel at the table.
3595. All right, here we go.
Thank you. All right, Mr. Waters, how are you?
Good morning, Your Honor. Good to see you.
Good to see you. Now, let me ask you, I know some of your counsel at the table, but I don't know all of them. Can you please just let me know who the state's team is?
So I have David Fernandez, Assistant Deputy Attorney General David Fernandez. He's my number 2 in the state grand jury section. I have my boss, Mr. Don Zelenka.
I know.
We have John Metters as well.
I know Mr. Matters.
See, Your Honor. You may see at various times. We have Assistant Attorney General Walt Whitmire, Senior Assistant Deputy Attorney General Melody Brown.
All right, welcome. Let me, Mr. Harpootlian, can you tell me, I think I know just about everybody at your table, maybe not everybody, but can you introduce the defense?
Please report, Your Honor. This is Jim Griffin.
Mr. Griffin.
Bill Barber.
Mr. Barber, good to have you. Okay.
I would just like to point out that of all the attorneys, both for the prosecution and for the defense, only one attorney did not stand for the judge, which you're supposed to do. It's rude. Come on, Jim. Also, I see that Miss Holly J has joined us. Hey, good to see you, babe. And as I live and breathe, it is my friend, longtime supporter of the channel, Amelia Sparkles. So good to see you, babe. I miss you around this place. Oh, another long-term supporter. As I live and breathe, I do declare. Chick Tracy, good to see you, babe. And Becky P, another longtime supporter. You guys are all really longtime supporters. I appreciate each and every one of you. I do declare. Becky P, good to see you. All right. Here we go. Jim Griffin already off to a crappy start because he's rude. He has the rudes.
All right. I've made some notes on a status conference, and I'll let y'all talk in just a little bit. But I want to go over what I want to go over. Because I want to make sure that all the discovery in this case is complete. And I made some notes, and let me tell y'all.
Let me just say this. Right from jump, she runs a tight ship, okay? Mr. Waters started to stand up to address the court and promptly took his seat due to the fact that she said, I made notes and we're fixing to talk about what I want to talk about. So sit down and just give it a moment. I like this judge already.
I don't know anything about the first trial, so when you tell me something, please be complete when you tell me, because don't assume that I know, because I don't. I want to know about phone records. Do we have all the phone records, and are they complete? Text messages, cell phone extractions, and if there's any supplemental extractions. video recordings, whether there's ballistic firearms, are we complete in that? Fingerprints, toxicology. I think there was a blood splatter expert last time. I just want to know where we are with these discovery items. I'll let the state address that, please.
Yes, ma'am, Your Honor. So we have provided, and obviously provided well in advance of the first trial, a very extensive discovery. I'm not aware of anything in the items that you mentioned that have not been provided to the defense. And if anything, the defense has more than the state does, because a very heavy privilege review was done, for example, on Murdaugh's phone, him formerly being an attorney and that sort of thing. So to my understanding, complete extractions were provided to them, whereas the prosecution team, the investigative team, only received the privilege review some kind of extractions as relates to this phone and that sort of thing. As always, we're constantly auditing and looking at everything, but I'm not aware of any discovery from these very extensive productions that were made, not only from just the murder investigations, but also from the very extensive state jury investigations as well. So he has provided those, and obviously I'm not aware of anything in the categories that you mentioned that have not been provided to me.
And not anything that needs to be reanalyzed or anything that the court would be waiting on?
At this time, no. Now, as you're aware, and we, of course, sent our responses to everyone last night to the defense motions that were filed late last week. Came in the office Sunday to write those. That one of those is their request for independent testing on DNA. We put it in our motion, and I actually got an email from Mr. Griffin this morning that if they want to have their defense expert reach out to SLED as to specifically what capabilities they think they have and what they're proposed to do, happy to facilitate those conversations and discuss those with the defense and then with Your Honor if necessary. Right now, that's kind of where we stand on that. And of course, any other issues that arise along those lines, we're very reasonable and we're perfectly willing to discuss those with the defense. And if there's something that we can't agree on, obviously we'll raise those to the court.
Hey, Sarah Bellum, good to see you, babe. Slightly late. Do we have the same cast of characters? Poot et al. Yes, we do. We have the same cast of characters representing Alex Murdaugh. So pretty. Although there is an attorney that I think I saw, but I'm not sure if they didn't. He wasn't introduced in the beginning, so I'm not sure if he's part of the team or not. So I'm just gonna, I think, but yeah, for all intents and purposes, yes.
Okay. All right, Mr. Harpootlian or Mr. Griffin?
Your Honor, I want to address everything but the DNA.
Right, I'll talk about the DNA later.
So we don't know what we don't know. And I'll give you an example. Let me hand this up to Your Honor and hand copies to. Your Honor, this is a transcript of an interview done with a guy named Chapman and another officer who were folks that arrived on the scene to begin with, to process the scene, and were very involved in the forensics of processing the scene. And if you go to page 6, Chapman, who's in charge of the scene, says this. This is a television interview on March 13th, 10 days after the verdict in this case. He says, in response to the question, I believe you had some help in the aftermath. Or Rutland, yes. Captain Chapman, you know, the disposal of weapons, the moving around the vehicle. We heard so much about SLED and AG's office, and they don't have anything. It's all circumstantial. So I pose this question to you. It was a clean crime scene, staged crime scene, clean crime scene. Would you expect to find more evidence or less? And that's what's kind of hard to get people to understand is we didn't find a lot, But why we didn't find lock? Because it was clean. I mean, it was manipulated. There's evidence removed from the scene. Now, this is 10 days after the trial. This is not what Chapman testified to. And if Chapman has evidence, there were other people at the scene, that he had assistance under their theory, or there were other people there, we need to have that furnished to us. And we have other witnesses that testified at trial who are saying something totally different, indicating there's evidence to believe that somebody else was at the scene, or there were other people at the scene. I mean, this guy's the chief guy in charge of the scene, along with Rutland, who processed it that night. We need, and we're in the process of doing this, to determine if they those statements or the reports. So we don't know what we don't know. We don't know what we don't have. We need some period of time to try to process that. And Your Honor, I say...
Hold on a minute, Poot. Now, come on. He's doing a good job, though. This, and it's interesting to me because they took on this case. Dick Harpootlian and Jim Griffin took on this case on a flat fee, okay, not a retainer where, you know, you keep funding, okay. This is a flat fee service, and so they've been paid, and they're still working on the case, right? But I find it very interesting. Some of the things that he is bringing up, and I mean, do I think it means what he is implying that it means? No. I think what happened, and I think I remember watching that interview and thinking to myself, okay, when you're on the stand, okay, and you're asked questions, okay, by, in this case, he would have been the state's witness. That's one thing. Okay, you answer the questions that are posed to you. That's it. That's all. Both by the whoever's witness it is, whether it's on direct or on cross-examination. Okay. Now, can you, at the end of after all is said and done, after the trial is over, the verdict has been rendered, all the things, can you have your own theory as to explain why there were things not found at the crime scene, specifically the firearms? They feel that there was not the firearms, because those were in evidence. Something else was missing. There were things missing from the crime scene that they would have expected it to be there, suggesting that it was manipulated. You can have that theory, right? You can, if you're asked in an interview after the fact, and they say, well, you know, what do you think about what was, you know, why there, this, you know, this, that, or the third, right? And he's answering and he's saying, well, you know, I think he had help after the fact. Once again, we're talking about knowing and proving. There are two very different things. You can have a theory, you can even know and be 90%, even 99% certain that happened, right? But being able to prove that in a court of law is two different things. And I think that all that detective was really doing was just saying, this is what I think, not that there is somebody else, and you know, that they have tangible evidence of who that person is that helped.
Yes. And no emphasis on trying to, we're not alleging that the state has hidden anything from us. We do know there were people that came to see us that said they had important information. We have no ability to investigate cases. We don't have subpoenas. We don't have grand jury. We don't have search warrants. And 2 or 3 of those people we sent to SLED. Did they follow up? One had extraordinary evidence about a tie-in between Paul's murder and the murder of a young man named Stephen Smith. But we had no, I can't compel anybody to come anywhere. We sent that to SLED. Did they investigate it? They investigated, and I must tell you, there are a lot of pieces of information out there and maybe they just stopped once they got the conviction, didn't do anything else, that it's inconsistent with our desire to get a conviction, have the conviction held. So they didn't follow it up. Maybe it does need to be followed up. But we're going to have to go back and look at all of that. We're going to have to determine whether or not additional material was developed since the trial. And of course, all of us were shocked by the court's conduct in the trial. I know we were, I know the state was. But it's caused us to go back and look at, and we haven't done a thorough check of it, all the testimony, and read it all, not in the sense of an appeal, which we've done, but in the sense of, in criminal cases, we don't have depositions. We don't have them here. We have a transcript but not every, I'm sure they're going to get rid of some of these witnesses. They're horrible first time around. We get additional witnesses. But most of the witnesses, we have their transcript, their deposition.
Black the milk truck up, Pooh. Which witnesses specifically were horrible? I'm going to have to go back and refresh myself on these. I wouldn't say horrible. I probably wouldn't phrase it quite that way, but I would say that there were a couple of expert witnesses that testified for the state that I think it was a wash. I think they neither helped nor hurt the state's case. But I will say this. The person who hurt the defense's case the most, in my opinion, is sitting at the defense table, Jim Griffin. I think that because of his way of cross-examination, he opened the door to things that were already going to be kept out, that the judge had said, okay, we're going to, there's some stuff respective to the financial crimes that's just absolutely not coming in. But then we're going to take a wait and see approach on the rest of it as the trial goes on, which I think was, the right move. But then Jim Griffin opened up the door. And then the second person that hurt the defense's case the most is Alex Murdaugh himself. Even though he got up there and ugly cried, I'm talking full tears, snot, snotting everywhere, the whole 9 yards, right? Even when he wasn't doing that, when he was testifying about the financial crimes, although I think his intention was to come across contrite, remorseful, he didn't. It did not come across sincerely, in my opinion. All right, let's keep going.
We need to go back and read all of that. We need to get a sense of how you prosecute, like you do in a civil case. So I can't say that we've got it all. I can't say that we don't have it all. Again, I don't know what I don't know. But I think we will be diligent. And one of the other things we talked about is Alex Murdaugh's access to that information in a way that makes it convenient for him and doesn't inconvenience anybody else. We'll talk about that. That's another motion we'll talk about that.
I'll get to your motions in just a little bit. What I really want to know is about phone records, text messages, cell phones, video recordings, toxicology, fingerprints. You have all that discovery.
We're not sure, but we need to review it as if we were getting ready. It's brand new. I can't just look at it.
What do you mean we need to get ready as if it's brand new? Are you kidding me? What have you, Poot, what have y'all been doing? Certainly, you had to have anticipated the probability, the high likelihood that this conviction was going to be overturned because of Becky. Okay? Certainly you had to entertain that thought. What the hell have y'all been doing this whole time? Y'all just wait. The Poot wanted this trial to be pushed way further out than the judge was like, no.
5 years ago, 4 years ago, doesn't mean we know we have it. And we'll be diligent in doing that, but certainly I would think it'll take us some period of time to review that.
Jim, he's looking at you. Help your man out. You're a terrible wingman. Hey, Kelly, good to see you. Sorry, I got yelly, y'all. He's a terrible wingman. Look at the Poot. What are you doing, Jim? Even the bailiff over here is like, bro, are you going to speak up? What's up? He's talking to you.
Yeah, I'll start out in the trial.
Right. One of the points, reminding me, we did not have OnStar data on Mr. Murdaugh's vehicle until halfway through the trial. That is not the Attorney General's fault. That is DNC's fault for not furnishing it. We had to do
Hey, Kimberly, good to see you, babe.
that on the run. We want to go back and analyze that, have an expert analyze that even more. I do want to emphasize the Attorney General got it at the same time we got it. No inference, anything improperly.
Okay.
So that's part of what we need to do. We need to hire additional experts based on some of the views we now have on some of the witnesses, both the state and the defense have. And they need to examine those reports to determine whether we have everything. So it's going to take a little bit of time, Judge. I can't tell you today we have everything because we don't know.
Okay. Let me ask you, Mr. Waters, what about the OnStar data? Do you have all of that?
Yes, ma'am. So, Your Honor, we actually SLED had sent 2 search warrants to GM well in advance of the trial, and we're told, you ain't got none. And I think what happened was during the course of the trial, we actually had the FBI buy a Suburban and essentially reverse engineer the black box in the Suburban in order to provide us telemetry data, which of course was all provided to the defense. I think when that testimony came out during trial, somebody at GM was watching and they were like, uh-oh. And so in the middle of the trial, I get a phone call saying, about all that OnStar data, actually, we got a bunch of it. We immediately advised the judge, advised the defense, provided that to a usual form. They assessed it and agreed to go forward because we each had our theories about what had to happen next. So that was nothing with the fault of the state, and we immediately engaged in what we needed to do to ensure the defense had access to all that information. As to him saying, we don't know what we don't know, well, I know my obligations are, and if I have knowledge of something that's disclosable, then it's been disclosed. And so to imply that there's something out there, we're always constantly auditing that and doing our obligations, but I take discovery obligations very, very seriously. Mr. Harker knows that. As far as these musings, I haven't watched this TV interview. The musings of some captain about, whether the scene was clean. Well, there was evidence presented at trial that it was standing water on the concrete pad of the kennels, that the hose was not put back the way that it normally was coiled by the person who was in charge of taking care of those kennels. So he may have been talking about that, but ultimately, while Colleton responded initially, the scene actually was in charge of the process by SLED, and they've had access to all that information. So to sit here and imply, we don't know what we don't know, well, I'll recognize that, but I know that my obligation is to provide that information to the defense, and if I'm aware of it, it's been provided. And we have done that. They've had it well before the original trial, and we will continue to do that. And as he freely recognizes, the OnStar data came in late despite our best efforts and was immediately disclosed to them. They had every opportunity to process that information, and then they agreed, you know what, let's continue on. So that's not any sort of indication of a bad process or practice on both sides.
So the bottom line is they have everything that you have.
My knowledge, yes, ma'am, and we were very careful about going through all that discovery.
And you don't know of anything else that needs to be analyzed at this time?
Well, again, we have that DNA.
The DNA, and I'm going to get to DNA in just a moment.
Of course, it was analyzed ahead of time. Now, what they're
Right.
talking about is some additional capability. And as I expressed in our motion, and Mr. Griffin has responded, I'm happy to facilitate discussions, and if there's some capability out there that's beyond the capability of SLED, and it has a reasonable chance of providing some sort of analysis, then we're happy to do that. Now, of course, if we put in our motion, ultimately, there's absolutely no evidence that Maggie Murdaugh was in a struggle with anyone, that she had any sort of defensive wounds, that she was scratched any sort of attacker. And we also know that it's very common how sensitive touch DNA is. We're constantly shedding DNA and picking up DNA from others by shaking hands and doorknobs and all the rest of it. So, this is a bit of a red herring.
Okay, so just to refresh your recollections, respective to the DNA, what they're talking about here is there was DNA from a man under Maggie, from a male, under Maggie's fingernails, okay? And they could not, there was a profile generated, but they could not and did not match that profile to anybody that they had taken DNA samples from regarding this in this case. Mr. Waters is saying, basically, this is much ado about nothing. It is not epithelial DNA, it is touch DNA. And so that could be from anything, and it could be, completely innocuous. And we, as the state, don't feel that that has anything to do with the crime at all. We had it tested, it was analyzed, it was compared, and it didn't match anybody. So, Mr. Griffin is going to talk about it a little bit in a little while, but that's basically what the deal is with the DNA.
Doesn't mean that we are not willing to discuss with the defense anything that they want to do, and if reasonable, we'll be the first to do that. And if there's any needs to come back to this court, we'll do that as well.
Okay, thank you. Sure.
We know from testimony in the first time that the chief SLED officer involved admitted he misrepresented things to the grand jury. Since the trial, the case was dismissed, in which he testified because the judge found he was hiding evidence and misrepresenting that. That's the chief officer. No other SLED. But it raises questions with us, not whether it's been withheld by the state, by the prosecution, but did he give them everything he had? Did he do what he did in the subsequent case after the trial when he had evidence? And I think we've got to go through it and look and say, are there gaps here? Are we missing something? And for us, and look, we want to try this case as quickly as possible. No question about it. But what we don't want to do is not be prepared based on what we now know happened at the first trial. And we'll have a motion probably next week that will expand on that a little bit. We didn't feel that we wanted such a motion as that.
Well, and I don't. I really wanted to go over and see where we were with discovery. I want to set a timeline. I want to set out some pretrial conferences, and I want to set a trial date. That's why we're here today. And I want to go over some of these motions. I think some of them are not substantive, that I could go ahead and rule on those today and be done. And I will set up a pretrial. I'll give y'all some dates and hope you brought your calendars. And we'll set a pretrial. I don't know that one pretrial is going to do it for this case. We'll probably have several. And that's fine. The court's amenable to anything that y'all need. And happy to hear what you have. If you find something, Mr. Harpoolian, that you need to bring to the court's attention and you want to file a motion, I am more than happy to hear it. Okay? All right, so let me move on to my next notes. and we've kind of touched on it a little bit, experts. Do you know how long? And the reason I'm just asking is because I do want to set a trial date. Believe it or not, overnight when I was assigned this case became the oldest case on my docket. And anybody who knows me knows that I will move an old case. And I intend to do that with this one. So, I'm asking, Mr. Waters, expert witnesses, do you know how long you need to get expert witnesses and talk to people and get everything that you need for the prosecution of this case?
Yes, ma'am. So the vast majority of our experts will be with SLED. And so I think that, we are ready, within reason, of course, to move this as expeditiously as possible. We do have another expert who testified from the FBI and things like that, but much of that is the same. And so as far as the state's position as to scheduling, and I know we've already sort of stated this publicly, that we were trying to do this before the end of the year, late towards the end of the year. We're ready to go put together about that. And so I'm not aware on the state side of any expert issues that would provide for additional delay.
All right, Mr. Harpootlian, how about for the defense?
Your Honor, we have 8 expert witnesses. All of them are new. All of them are just beginning to get the information they need. The DNA, when we are told, may take up to 6 months. It is, unlike what's been represented by the state, critical. And Mr. Griffin will address the specifics of that in just a moment. But to try this case this year, these guys are talking about going to the death penalty 4 months ago or 3 months ago. To try it before the end of the year cannot be done for us to be adequately prepared. And we talked about the laptop. Without the laptop, we can't try next year. If we have to go down there and take in the banker's box at a time to read documents, almost 20,000 pages of documents. So we came up with a way to
Well, surely, Mr. Harpootlian, he reviewed those before his first trial, did he not?
5 years ago. I mean, it's just a judge. I can't remember a case I tried 3 months ago when the material was on. I mean, it's ridiculous to require him, not with all due respect, to require him to have a memory of each document that he looked at almost 5 years ago. And by the way, our solution to that, contrary to Mr. Waters' motion, is ironclad. There's no chance of it being distributed. We'll give him a laptop that's encrypted, since there's no attorney-client on it. Corrections can look at it. SLED can look at it. Anybody can look at it. And let him look at it without us having to take hard copies of stuff down there and review it with him. You can't leave it with him under the court order. In other words, you just can't take him to discovery and leave it. There's a court order prohibiting that. And I'm sure the warden does not want boxes and boxes of stuff sitting in his. But if we have that, and he could be reviewing these documents and experts as we're reviewing them. I mean, let's not forget, he's a lawyer. Now, he's a disbarred lawyer, but he has probably more trial experience than many of the folks on either side of this. So he understands what he's looking at much better than any client I've ever had. So I think it's important, if you're going to try to expedite this, for him to have, and we can talk about the laptop separately, but that's going to be a condition. It's going to take us at least 6 months to get these folks retained, have them look at the adequate material, look at the state's testimony the first time around, and of course if they have a change in who they're using or taking a different approach, we need to know that as soon as possible. I would point out that they were giving us discovery in the last case after the first week of trial, in the second week of trial. So we can't have that happen again. They say they've got it all. We're going to assume we have it all unless they want to supplement it. They supplement it sooner rather than later. That allows us to do that. I mean, I think what we probably ought to try to do is figure out a trial date And then back up from that, what we're comfortable with is late spring, early summer next year.
Okay.
We can live with that. Given, if we have to go down there, one of us has to go down there 5 days a week, and you are incarcerated on now, so there's 2.5 hours from here. It's a half an hour to get in. So before you even see it, it's 3 hours. And then you only have 3 hours with them, and then it's a 3-hour trip back. That's why the laptop is so important.
Okay. Mr. Griffin, anything you'd like to add as to experts?
I have been in contact with the DNA lab in Houston. I can talk more about that. But when I mentioned that, they were asked, how soon do you need it? And I said, well, hopefully we're looking at a spring, early summer trial date. And the answer was, well, we need to put a rush on it. And I can talk more about the lab if Your Honor wants to hear it. I mean, they are the...
I'll get to the DNA in just a minute. And then we'll go forward on that.
Bless her heart. This judge has said, I think 5 times. And by the way, hold on a second. Her name is Judge Deborah McCaslin. It's Judge McCaslin who's presiding. But she said, I think 5 times. I'll get to the DNA in just a little bit, because what they want to do, and I think this is a very interesting and novel approach. I think this is actually kind of a good idea. And I touched on this a little bit last night with the West Memphis 3, because what they're proposing to do with Alex Murdaugh is what I would like to happen with the West Memphis 3 case. Hey, Brandy, good to see you, babe. All right, here we go. I will say, because I forgot this, sorry, that Dick Harpootlian brought up just moments ago that the state had indicated the possibility of them pursuing the death penalty. Now, I did listen to this hearing, but in my defense, while I was listening to it, I was blow drying my hair. So there are parts of it that I missed, and I am anxiously awaiting Mr. Waters' response, because I'm very curious. Nothing that I found so far indicates one way or the other whether they intend to pursue the death penalty, although I would imagine that the time for that is fastly approaching. If they're going to do it, they need to announce it now.
All right. Let me talk about this computer at the Department of Corrections. I did receive your response, Mr. Waters, yesterday at 5. Did you get the opportunity to look at that, Mr. Harpootlian? I mean, basically, I just made myself some notes. You were concerned about the state grand jury material, and talked about a protective order, and some other issues. I agree about there are some sensitive issues. The state grand jury material is protected and should be protected. And then you mentioned an order that Judge Newman had. I kind of think, Mr. Waters, that when this case was reversed, that order goes out the window and we might need a new order for this case. It's my understanding that the order stated that the grand jury material is secret. And I mean, that's pretty straightforward. And I know that you would like to prohibit the digital dissemination of the state grand jury material, that there's no photocopying, scanning. I breezed through this. You don't want any digital copies. And all of this while it doesn't prohibit the defendant from reviewing the case materials, you want the attorneys to make sure that they keep in their possession the state grand jury material. Is there any objection to that, Mr. Harpootlian?
Your Honor, the issue of that is what is the state grand jury material? I think, if we can designate what that is. It's beyond grand jury testimony, there's very little of that in the discovery. I think they've gotten things through grand jury subpoenas that have been produced, underlying records and whatnot. And so, is that really sensitive grand jury material? And some of us introducing evidence at the trial, I'm sure of that. But, so no question about grand jury testimony. We have no issues with that. But it's just hard to say what exactly are grand jury materials when a lot of subpoenaed documents and information have been produced. That's all.
And Your Honor, if the issue is dissemination, he has a right to read it.
Oh, absolutely. I said that. It does not prohibit him from reading it.
The issue is dissemination. We're just basically talking about the Kindle. You can read on it. You can't send emails. It's not connected digitally or cell or Wi-Fi to anybody. It can be kept. Let me say this, the Department of Corrections has been extraordinarily professional in dealing with us, giving us access to that. But no complaints with them whatsoever. But what we'd like that laptop with the warden and corrections to have total access to it. It can be inspected by SLED to make sure it can't transmit an image, a message, and be used in any way. There is no Wi-Fi that fits a particular institution. So it has to be by self-service. These are not difficult technical issues. And if they're concerned about grand jury testimony, we have to take that out. That's a local matter of what we want him to look at. And we can certainly do that separately with hard copies. We'd be happy to go down there and do that.
Yeah, but Mr. Harpootlian, I don't think that you are appreciating where your client resides currently and where he will be continuing to reside for the foreseeable future, up until it's time for the trial. Then he'll be moved and he'll be housed at the county jail. But the thing is, he's in prison right now. And yes, his conviction has been overturned for the murder trial, but his other convictions haven't. He's pled guilty to financial crimes. He's got federal cases also pending. So the warden of the prison is responsible for maintaining the safety of your client and everybody else, both housed in prison and also working in the prison. And if they let Alex Murdaugh have a laptop because he is an attorney, and even though he's been disbarred, he can, him being disbarred does not negate his education and his experience. And that, though you can't take that away from him, that happened. But there's no way the prison is going to let homeboy have a laptop, because if they let him have a laptop, then okay, there are people in prison with Alex Murdaugh right now who are appealing their convictions, but they're doing it pro se. So are they going to be granted access to a laptop? Come on, think about it. Like, Jesus. Come on, Poot.
Well, let me tell you. Mr. Waters, let me hear from you first.
Yes, ma'am. So we really, as far as the protective order, we really have two things. There was the state grand jury investigation, and ultimately there was the standard protective order for that.
Hold on, I want to say hi to Cement Shoes. Hey, babe, good to see ya. All right, let me rewind a couple. Let's go back and let's hear what Mr. Waters has to say without interruption. I apologize, Mr. Waters, for interrupting you.
So we really, as far as the protective order, we really have two things. There was the state grand jury investigation, and ultimately there was the standard protective order for that. He's pled guilty to all those offenses. There's nothing reproaching about that. And necessarily, as that state grand jury investigation was going, things came up that were ultimately relevant to the murder. So it's much bigger than they say. I don't have the number in front of me, Your Honor, but it was at least 20 witnesses, multiple subpoenas, and so all of this has been dynamic. And as well as Judge Newman issued a second, to my recollection, protective order as it related to just sort of the murder evidence as well. So they're two separate things, but they all blend together. And so all of this evidence is sensitive. On top of that, the murder evidence is in fact very, very sensitive. And frankly, we've been trying our best to protect it from improper dissemination because it's worth a lot of money. Now, one thing SCDC is adamantly opposed to, okay, is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away from misuse of that. This is an individual who was caught receiving contraband that was passed from a family member through the defense to him, found like that. And so this is not a guy who is, and this is also a guy who's been convicted of over a decade of fraud. Now, they say that these things can be locked down and made to safe and whatever. I understand these issues very well. As the state grand jury made a point to partner with SCDC to fight the problem of fraud and corruption emanating from there, and it's done with the use of devices. This is a very severe security issue, and no matter what protections are put in place, there's always ways around this, and SCDC has experience with that. So the fact remains is he's an inmate, and SCDC is adamantly opposed to there being some laptop that he has access to. And for this idea that SLED is going to be able to review, attorney communications and work product on that, I don't understand how that's going to happen. Now, SCDC is happy to accommodate and to any meetings they have. And no one says that the defense can't bring down digital evidence to review with them while it's under their supervision and then take it with them when they leave. That is absolutely the way it should be, that ultimately this information, whether state grand jury or not, is too sensitive to have an inmate, despite what protections are put in place, have a laptop, because frankly, the reality is inmates are constantly and successfully violating whatever protections. Despite everyone's best efforts, you're doing a great job. It's just a natural.
Okay. Sure.
Hold on before you say anything. I just want to address what Mr. Waters said. He's right. I totally had forgotten about Murdaugh getting in trouble with his tablet. Because again, and I think this personally, at the end of the day, Murdaugh is a criminal. His conviction has been overturned, but let's remember why it was overturned. It was overturned because of Becky and her jury tampering, not because of anything pertaining to the evidence against him. Okay, it was because of what happened with the jury. Just like Otisha Lynn over there, this is not anything like when the West Memphis 3 applied for DNA testing back in 2007, and they were going to be granted a new trial. Okay, that type of evidence has to do with an actual innocence claim. And this is not that at all. Not even in the neighborhood of that. Not even in the same city, not the same state, not the same zip code, nothing. Okay, this is completely different. And he is a criminal who, for years, for decades, stole from his clients. He is a liar. He committed and is convicted and pleaded guilty to fraud, which is obviously dishonest. So for the defense to think that they're going to give that Alex Murdaugh is going to have access to a laptop, and based on his word and some supervision from the prison, that he's not going to disseminate or do anything nefarious with this information, who would believe him? You can't take Alex Murdaugh at his word. He's a lying liar face who tells lies. He lied to the people that he was supposed to represent. He stole their money. He stole their money. They were paying him a fee for a job, okay? This isn't like he was some pro bono do-gooder, right, out there just doing, the Lord's work for free and helping people out. No. He was paid for it, and he was greedy, and he took money on top of that. Get bent, Murdaugh. I wouldn't even give you paper and pen. How about that?
I had a series of emails, and I don't see the Department of Corrections here today to check it. I had email chain with the warden at the particular institution, and he doesn't raise those objections. He just, and we would bring another laptop with internet cellular or Wi-Fi capabilities.
I forgot to say hi to you, ATS News. Good to see you, babe.
So, and that's what this says. So, and with all due respect to the Department of Corrections, if we don't get the ability, I mean, if Mr. Griffin and I, or Mr. Barber, or Ms. Fox have to go down there, 3 hours down, sit with them for 3 hours, 3 hours back, we're talking about at least the end of next year, if not the beginning of the following year, to get this support. We can't be working on experts, and we can't be interviewing witnesses while we're tied to sitting there and babysitting him while he's reading a laptop that doesn't have any capability to communicate or copy. And we'll be happy to have SWED inspect it. We'll be happy to have the Department of Corrections inspect it. But
not okay. Harpootlian, come on. Are you being this intentionally obtuse? Like, is this an intentional level of obtuseness that you're displaying here? Dissemination can be a lot of different ways. And so, yeah, in theory, if a laptop does not have access to the internet, then obviously it would be, you couldn't disseminate sensitive material over the internet, okay? Because there's no internet capability, all right? There are other ways of disseminating things. By Alex Murdaugh having copies of things and talking to other people. That, come on. I don't even have I have a GED. I have no college education, and I'm not an attorney, but even I can see the problem here. Stop playing with these people, Poot.
The idea, we bring laptops in. We would give him, as you can see, permission to bring laptops in. Laptops are brought in all the time. The question is, can he keep, not he, but can the warden keep it?
Yeah, but you can, y'all are allowed to bring in a laptop. You as the attorney, right? The warden is going to trust you with that. That's, you're an officer of the court, okay? But I would like to remind everybody that at one time, Alex Murdaugh was also considered an officer of the court. And look how he behaved. Like a complete a-hole. Okay? So, I mean, God, come on. The warden is not going to let you have your client keep a damn laptop. No, I mean, and I don't mean even like permanently, but like have a laptop that he can check out. He already acted a fool when it came to the tablet. So
what a bunch of a-holes.
That's all I got to say about that. All right, let's keep going.
Some office at the institution keep it and give it to him when he needs it. And Your Honor, I gotta say, the idea of bringing him in here chained up, the idea of not letting him have access to a laptop, the idea of opposing everything we're trying to do to expedite this process. I understand it's Mr. Waters' job to legally prejudice the defendant, but this is beyond the pale.
Oh my God, are you really going here, Poot? Look at you. It's not even noon in the Central Time Zone, the Pacific Time Zone, or the Mountain Time Zone, and you got me yelling, Poot. Got me all yelly at 11 a.m. on a Tuesday morning. Let me get a hold of myself. This is not beyond the pale. Stop it. Stop it right now. Okay? The fact of the matter is, the reason that your client is sitting there in shackles is because he pleaded guilty to a host of financial crimes. He is considered convicted. He resides at the prison. Okay? And the transferring him back and forth from the courtroom to the prison is a safety concern for everybody at the prison. That's what the warden's job is to do, is to protect the people in the prison, both the prisoners, the inmates, and the staff. Okay. And Alex Murdaugh has already proven that he is a shady boots motherfucker and has been given contraband. Now, how did he have access to contraband? Well, it was from his family, who was in the courtroom. Stop it. And I'll tell you another thing. If you be careful what you wish for, Poot. Remember where your client is being housed, okay? He's gonna, if the other inmates start seeing, oh, Alex Murdaugh getting preferential and special treatment, he's going to be a target, dummy. God.
This is beyond the pale. I'd ask you to remind Mr. Waters that he has an ethical duty to see that justice is done, not to get a conviction. Thank you.
Mr. Harper knows some facts.
I don't.
And that,
Okay, we're not going to go there.
and I have no intent to prejudice anyone. Prejudice suggests a decision on an improper basis.
And the court doesn't take it that way, Mr. Waters.
Thank you, Your Honor.
All right, let me tell both of you. I took the liberty of calling the warden and talking to him about the laptop situation. And because I too used to practice law, I remember terabytes of discovery that I had to carry to my clients to go see. And I know that it can be cumbersome, and I would imagine the discovery in this case is a lot.
Excuse me, Judge. Yes, we do. And as soon as this is over, we will discuss. Let me let the judge speak, because this is what Judge Newman faced. You know, Dick Carpootlian. Now listen, Poot. You're testing my patience, bro. Okay? I know you don't care, but it is what it is. I'm going to say it anyways. You're testing my patience. At the end of the day, you know, I love to hate you, frankly. That's how I feel about the Poot. All right? I appreciate the fact that you're advocating for your client. That's what you're supposed to do. And I will say this. If Alex Murdaugh had done his job and advocated responsibly and ethically for his clients, he wouldn't be sitting where he's at right now, because he wouldn't have murdered his wife and his son. Now, that being said, this is a lot of the issues that Judge Newman faced, is the Poot over here being shady, just throwing all kinds of shade. And, you know, just on, like, this is like a sidebar, all right? I know some of y'all followed the situation between Brittany J. and Julie Skolnick, okay? Two creators. Julie Skolnick had filed a civil complaint against Brittany and her and her husband or spouse or boyfriend. I don't know how you guys want to term it. She refers to him as her spouse, and I ain't taking that from her. Okay, so whatever. It doesn't matter to me, really, whether she's his spouse or he's the boyfriend. It doesn't matter. I don't care. That doesn't make any difference. Anyway, at the end of the day, Julie had some things to say about how upset the prosecutor in her case was about the things that were said regarding him online. And the fact of the matter is that most lawyers take their oath very, very seriously. And when you are an attorney and you are a trial attorney, especially, okay, and you go to trial, whether that is civilly or criminally, your word is what you have, because your word and your words are what you use to do your job. So when somebody throws shade at you and implies, particularly another attorney, that you're doing something that is not on the up and up, questioning your ethics, questioning your morals, that is a problem. And all attorneys would be angry about that. Okay. So there you have it. Hey, Tracy, good to see you. But that is why the prosecutor in her case, and that is why the prosecutor in this case had took issue with that accusation, and they should. And, look how people act on the internet when they're called liars. They're ready to snatch some souls like, let me just, end bloodlines. Like Shang Tsung out here talking about your soul is mine, because they're called a liar.
How many pages do we have, Mr. Waters?
11 billion.
It's very extensive. It's half a terabyte.
Half of a terabyte. Okay. I talked to the warden. He will not allow a laptop. And for safety reasons, he said he would, quote, make available a conference room. Counsel may bring their computer. They could have a law clerk come, or the attorneys could come themselves. They could look at it. He could review his discovery. They could bring their own laptop. However, somebody must be with him. His concern was having a laptop in his cell. No other inmate has a laptop in their cell. They do have access to an iPad that has Westlaw on it. Now, I just have to be honest with you. I didn't even think about asking him if you could download any discovery on that iPad. I don't know if that's available, but I certainly will call and check and see if that's acceptable to him. If that's the case, I'm going to have Mr. Waters draw me up a proposed order on the state grand jury material. I haven't looked at Judge Newman's yet, but I will. Please run that proposed order by Mr. Harpoolian and Mr. Griffin. I will check on the downloading on an iPad, but I'm not going to allow him to have a laptop computer in his cell. It's for safety reasons. That's out of my control. I think it's not only for the safety of the others at the institution, but probably, Mr. Murdaugh, for your own safety. Okay.
All right. Before we get into the next part of this, all right. Here we go. I searched Alex Murdaugh contraband. Alex Murdaugh has faced multiple incidents and reprimands for possessing and attempting to pass unauthorized items while incarcerated and on trial. Hang on just a minute. Let me make it like this so we can focus. I can focus anyway. All right. Breakdown of his contraband-related incidents includes courtroom book incident. During his 2023 murder trial, Murdaugh received a misdemeanor charge for possession of jailhouse contraband. The item was a book handed to him at the defense table by his sister, which is in direct violation of jail regulations, privilege violations. In subsequent custody, Murdaugh was disciplined and had his tablet privileges revoked for using fellow inmates' pins to make unauthorized calls. Broader prison network allegations. Beyond his own disciplinary infractions, Murdaugh's name has been broadly linked to contraband investigations within the South Carolina Department of Corrections. Reports from investigations such as sprawling prison, as the sprawling, quote, prison empire probe have alleged his involvement in the trafficking networks operating beyond state prison walls. Oh my damn. All right. So there you go. Now, let me look because there's nothing about this drone situation. So I don't remember what you guys are talking about. Although, was there a drone? Hold on. Ah. No. Was it? Hold on. I don't know. I don't know. Let me see. So what did he do with the drone? Was it over the prison? Is that what it was? Hold on. Let me see if I can find it. Let's see. I can't. It says when the AI overview says Alex Murdaugh himself has not been implicated in smuggling contraband via drone. However, the South Carolina Department of Corrections frequently intercepts drones smuggling illegal goods like drugs, cell phones, crab legs, and steaks into state facilities. Wow. For example, officials thwarted a massive contraband drop and intercepted a planned crab boil at Lee Correctional Institute. Murdaugh was previously held at the heavily monitored McCormick Correctional Institution and continues to serve his sentence in South Carolina following the South Carolina Supreme Court's decision to overturn his convictions. All right, let's keep going on this. What is it? It was on Jumpsuit Pablo. Okay, I'll go look it up and then we'll talk about it later.
We're not proposing he have it in his cell. We're proposing that the warden have it and give it to him to go to a conference room as he would with us to look at it there. Does that make a difference?
Well, I'll ask him. But when I read your email here, this seems like he could go to his cell. He could keep it in his cell. I know good and well that the warden is not going to allow that. I talked to him personally.
That's an objection.
Okay. We'll follow up on that in our next pretrial. Or if I can, I'll probably let you know before pretrial. But if he says no and it's for security reasons, then the answer is no. I'm not going to allow it. Do you understand? Mr. Harpelian? Mr. Waters? He'd let a paralegal go. All he wants is the name of the person, and you're more than happy. And he said he's not going to limit you to 3 hours. They can stay 8 hours if they want. He will make a conference room available so he could see the material. It does not have to be a lawyer. Okay, that.
Your Honor, I spoke with the director of Federal Counsel this morning, and they expressed the same thing. We're here to facilitate the defense doing that.
Right. You know, I want him to have all his discovery. He's entitled to all of it. You know, it's safety concerns. It's.
Poop. They're gonna help you out. Okay, they're happy to facilitate reasonable requests that will aid in Mr. Murdaugh being able to prepare for trial. That is a right that he is afforded under the Constitution of these United States. They're willing to accommodate you. What they ain't finna do is give that full special privileges. Stop playing with these people. Just say, thank you, Your Honor. Sit down and figure out a better way to get this done. That is it. That is all.
If you can have a law clerk or a paralegal go down, then you're satisfied, Mr. Harpootlian, that'll help you out?
Automatically, we're not limited to 3 hours. It makes that 2.5 hour trip down and 2.5 hour back worthwhile.
Okay. Well, then I will verify that and send y'all an email tomorrow on that. That's okay. All right, perfect.
Thank you, Your Honor.
All right. Now, let me go through. I had a motion filed for the defense, and I just want to put this on the record. The defense wanted the defendant to be unshackled in the courtroom. I received a response from the state. They objected. Then I had a response from Mr. Harpootlian where he withdrew that motion. That still stands, Mr. Harpootlian?
Yes, Your Honor, although we may renew the motion, our reason for this is potential jurors are watching this right now. It's going to be, wherever this goes, it's going to be difficult to get a jury. And to the extent that parading him around in a jumpsuit shackled like an animal impacts their view, it's going to make it more difficult for us to get a jury. Now, again, Mr. Walter's argument is specious. He's not dangerous. The only thing he can convict of is stealing money. Now, Judge Newman let him come to the courtroom in street clothes and unshackled. I know Mr. Waters feels compelled to get every advantage he can, but this is one that I think this is our ability to get a jury. So I would ask that he be allowed to come in the courtroom unshackled in, I will call them street clothes. Now,
So are you renewing your motion now? Just want to make sure.
what I wanted you to see today is this. I mean, chained around the waist, chained to the hands, chained on the feet. I mean, this guy is not a serial killer. He's not, Ted Bundy.
You could sit down, Mr. Murdaugh.
Look, Poop, I personally believe that after the first trial that there was enough evidence beyond a reasonable doubt. I think that the jury found him guilty, and I think correctly. I think he is responsible for the deaths, the murders of his wife and his son. Okay? Now, legally, his conviction for those murders has been overturned. So at present, he stands accused of murder. All right? However, given the fact that he has been in jail awaiting the first trial and now prison, and he still can't, won't, don't follow the rules, tells me that he has a mindset that the rules do not apply to him. And I think that is largely due to the fact that for years, decades out in the free world, they didn't. He didn't think that they would. A lot of it has to do with his family name and their standing in the community. And he got away with a lot of shit he shouldn't have ever gotten away with, probably from even as a kid. Okay. And so whatever, Mr. Harpootlian, he's shackled because that is the way prisoners are transported, regardless of their crime. Whether their crime is a violent crime or not, that is prison policy. So there you have it. It has nothing to do with Mr. Waters. Mr. Waters is not in charge of the facility. He's not in charge of their operations day to day or otherwise. That is a prison policy, not a Mr. Waters policy. And quite frankly, the fact of the matter is this. In terms of jury selection and the trial, yes, it has been well established. The U.S. Supreme Court has ruled on this, that defendants should not be, the jury should not see the defendant's shackles. Should not come to trial wearing the prison jumpsuit, because it is prejudicial. The other fact of the matter is, this was a very highly publicized case. There have been numerous documentaries done prior to the trial and after the trial. Okay, it's going to be difficult anyway to seat a jury. That's just facts at this point. Okay, I don't think that seeing him pre-trial like this is going to prejudice anybody. And if it were going to prejudice them, you wouldn't want them on the jury any damn ass way. Okay, stop playing with these people. All right, he is being shackled and transported in the way that is in accordance with the prison rules.
He's accused of killing his wife and son. But he was accused of killing his wife and son when Judge Newman allowed him to come unshackled in his street clothes every hearing that he had.
All right, Mr. Waters, I did read your response.
But there's a big difference in coming to pretrial motions when you're being held at the county jail versus prison. It's just different. Logistically.
But I'll be happy to hear anything, and I'll take it under advisement.
Well, again, they've withdrawn the motion, and now they've...
Now they
This goes back to, it's not the state's fault. He's an inmate serving a 27-year sentence, okay? This is, again, SCDC's policy for a non-jury court. It's going to be dressed out in restraints. He not only faces 27 years, but an additional 40 years in federal court, and he's also indicted for a double murder. So this is a basic security consideration. Again, the intent is not to prejudice anyone. The intent is the security of every time someone is transported out of court. It is a security risk. And the first two goals in any escape attempt is to become unrestrained and in civilian clothes. So I'm here to represent what is basic policy and procedure for inmates serving long felonious sentences with SCDC. I completely understand that we have a jury, the calculations are different, and that is going to be a different thing to do. The remedy for all of that ultimately is the our process. It's going to be jury selection, and it's going to be instruction from the court, which the jurors need to follow, and which I know our citizens can.
Okay, thank you.
This is an excellent point by Cement Shoes. What's funny is Ted Bundy wasn't shackled in court. He was parading around like man of the hour wearing street clothes. He was. That awful laugh of his. Oh, it's like some weird hybrid of the Count, when he would laugh. Like, ugh.
All right, I'll take it under advisement, and I'll issue an order on that.
Hold on, I forgot to say good morning and hello to Coffee and Skeletons. Good to see you, babe.
Let me move on to the DNA. Again, I just received the state's response yesterday at 5 p.m. I read it, and I'm going to save it for the next pre-trial because this is what I want to know. I'd like to know how long, Mr. Griffin, it's going to take to analyze exactly what it is you're asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab.
Okay.
So
And
that was conveyed to them this morning. The CEO of Othram's name, email, and telephone number. They have received the VP of Law Enforcement Division at Othram, his cell phone number, and the client intake person that we use now, that I've been interfacing with, and they will be better able to answer specifically how long it will take. We've agreed to pay for it, and just background information.
I'm gonna let you pay for it.
And these murders happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021, this genetic genealogy was just on the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021. It does exist today, and Othram is the leading lab that performs this analysis. They did last year on 2024, the statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country. They work with law enforcement every day. The most high-profile case they did was at the University of Idaho, the Moscow, Idaho murders that took place about the first week of our trial. College kids were massacred in a house at the University of Idaho. They had a DNA sample they ran through CODIS. Came up nothing. There was nothing. The state of Idaho Police Department, like SLED, had a contract with Othram. They sent the test Othram. Othram does this genetic genealogy DNA analysis, and it comes back to a family member who'd done a DNA test, ancestry test, of the person who committed these murders, Brian Koberg. That's how they solved the Moscow murder cases, was through Othram lab. The difference between, and they say they don't have enough samples to get through CODIS, and I've talked to the lab about that, and that's not an issue. CODIS uses analysis called STR. This analysis is SNP, and they call it SNPs. CODIS has 20 data points. SNPs has 500,000 data points that they analyze. Now, it takes a while to do that. And so, we're going to have to see what the lab says. They've asked me to get information from SLED as to, they'd like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd asked Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab. There are handfuls of labs around the country, and they are they're certified. They work with law enforcement. I don't know that they've worked specifically with SLED. They're familiar with SLED when I spoke with them, but they have a whole division.
So you need an expert's name or whoever has this sample to see if there's a viable sample that you can send. That
correct.
They could send.
And they can work with the extract that SLED used when they did their STR analysis. They can work with that out there. They told me, but
Mr. Waters, can you give him a name so he can move forward?
That's what I put in my motion, Your Honor, is please give us a name, and I'm happy to have SLED reach out and talk to them about what their supposed capabilities and proposals are and any procedures. And I'm then, once made privy to that information, I'm happy to discuss those with the defense. If for whatever reason we can't agree, we'll come back before Your Honor. That's precisely what I put in my motion is let's talk to, let the experts talk so that my experts can hear, what it is that they propose to do. And I'm happy to consider.
and I gave him 3 names and contact information this morning, and I've asked a name that I can send back to my folks. I do want to address this red herring argument.
Hang on while he, right before, just let's unpack what he said, okay? So basically what they want to do is take the DNA from under Maggie's fingernails, the profile, and run it through genetic ancestry DNA. They want to, to determine if they can't find a hit through CODIS, then let's see who this person might be related to. Okay. That's what they want to do. This is what I would love to see done in the West Memphis 3 case, because there is a profile that was generated. It came from the eyelet. I think that's what it's called. It's where you stick the shoelace, the hole, the outside. It came from there on one of the shoes. There is a male profile that has not been run through CODIS, but let's say it is, and they don't get a hit. CODIS is only for people who have been charged or convicted of a felony. And so they take a buccal swab, they swab, and they enter their DNA profile into the database. But if the person who is responsible for these crimes has not ever been charged or convicted of a felony, then their DNA won't be in CODIS. And so, but it might be not their direct DNA, but familial DNA in these other databases. And that is what I would like to see happen with the West Memphis 3 case. And Becky says, run it through and see what it finds for what? I think it is the defense's contention. Their theory of the case is that Alex Murdaugh did not commit these crimes, but these crimes were committed by another person. And at the very beginning of the hearing, Dick Harpootlian said that they received information that they had passed on to SLED that the murder of Paul is connected to the murder of Stephen Smith. And that is, they think that somebody else committed this crime, and that running it through the genealogy DNA database will tell them the true perpetrator. And the other thing that I wanted to say really quickly about the West Memphis 3 that I neglected to say yesterday is that I really need to get Dan Stidham's book. I haven't read it yet. I have read Terry Hobbs. I've not read John Mark Byers' book either. I need to get those 2 books. I'd really like to read those because I do remember it was either in 2025 or 2024, Dan Stidham, who was Jesse Miss Kelly Jr.'s trial attorney. He's now a judge. But he did an interview with the news, and he talked about his theory of the case based on evidence. And he, if I'm not mistaken, his theory is that it was that the murders were perpetrated by a truck driver, and that they have a suspect in mind. Of course, he didn't name names, but I just, it just made me think of that. And I just reminded me I needed to get his book. And that like 80% of the thoughts that are milling around in my head come out of my mouth. So here we are. All right, let's keep going.
DNA that we're talking about, Your Honor, came from Maggie Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alex Murdaugh's. Any of the other folks who they took buccal swabs from went through a long list, not them, except for one potential, and that potential, the ultimate result was it's 11 times more an unknown male, so they know it's a male, than it was this person. That's how they do things in their DNA analysis. And Mr. Waters said, well, there's no evidence of struggle, but there was a shell casing under Maggie Murdaugh's body from the gun that killed her. I mean, that shell casing and that gun had to be in very close proximity. Maggie Murdaugh's cell phone was missing from the crime scene. Was DNA transferred at that point in time? And so we don't think it's a red herring. We think it's very important. Now, it may turn out to be, innocuous. We don't know, but it's worth looking into.
Okay, I haven't said no. This is what I do want you to do, though, Mr. Griffin. I want to know how long it's going to take to analyze what it is that you're asking for. And even if I expedite it, I'd like to know how long it's going to take. And I'd also like to know if there's even a viable sample that they can get. And we will discuss this at our next pretrial. Anything, Mr. Waters, you're going to give them the name of the person at SLED that he can get in contact with. Let's see if there's a viable sample.
And the lab has told me if there's not a viable sample, we'll tell you that. But
Right.
they work with a lot less than.
Okay.
SLED.
Well, let's start with that. Let's make sure we get a viable sample, and then we'll go forward, and we're going to go forward at the next pretrial. I promise you, the pretrial is not going to be that far away. All right. Let me move on to the motion for change of venue. The defense filed a change of venue motion. The state has not had the opportunity to answer yet. So I'm going to give them time. In the meantime, before our next pretrial, if at all possible, if y'all agree on a change of venue, please give me some suggestions if y'all can agree on it. If you can't, make your own suggestions, and then I will decide for you.
Cement Shoe says, I didn't know Byers and Hobbs wrote books. Didn't Byers pass away? Yes, he did. He was killed in a car accident in 2021, I think.
If we go that route.
He, in spite of the acrimony here today, and they able to talk to each other, and we have already talked about this. I think we'll have continuing discussions, and depending on when you set your next
An answer for me?
It was 2020. That's my bad. God, it was forever ago. All right, here we go.
try, I don't have to keep driving down the public.
Yes, Your Honor. Of course, without taking a specific position right now, I've
Right.
Mr. Harpootling this morning that, we can kick some things around. And like you just said, if we agree, great. If we don't, then of course we'll decide.
That's right. Don't have a problem with that. Okay, perfect. All right, now let me address, I see Mr. McCullough sitting out there, and then I also have another, they're both the same protective order, but they're wanting two different things.
Ours is not the same as this.
That's right, they're two different things. Right. As far as, but I think before we go there, Mr. Harpootlian, I believe, Mr. Waters, am I correct in stating that you're working on a response to both of these? There might be some redactions that you wanted, and you're going to submit that to the court? Okay, and I'll be able to address that at the next pretrial conference.
Again, we are generally in favor of those being unsealed, but they will have to be done judiciously and with appropriate redactions to preserve their identities.
Right, because I did receive something from SLED, an email from SLED.
General Counsel Alan Whitsley was present here today, and SLED.
Where is he? Okay, I did receive your email, and just get me an answer on that, and we'll decide at the next pretrial then. Okay, those were all my bullet points. So let me ask the lawyers, did I miss something? Is there something you would like to add?
One thing Your Honor had mentioned is the location of pretrial hearings, and from the state's perspective, we're happy to come to wherever Your Honor happens to be and for the proper sequence.
Okay.
We're more than than happy to come wherever you are, although this production of these hearings might not dictate, but certainly suggest you come to a venue like Washington County, where there's plenty of room and have an extraordinary accommodated everybody.
I think they've done a really good job with security and with the press and being organized. And this is my home county. Let me just ask and throw this out there. Mr. Waters, is there any objection if we hold pretrial here? The reason being, we have a big courtroom. I already have security set in place. I think the clerks and both clerks and security have done a really good job. This is not the only courtroom in this courthouse, so I won't disrupt holding court in Lexington.
Okay, to answer Jonah's mom, her name is Judge McCaslin. I think that's how I'm saying it right. Let me see. Yeah, Deborah McCaslin. That is the judge who's presiding over Alex Murdaugh's criminal trial. Now, to answer, I just wanted to do a little quick check. Mr. McCullough, the attorney that is sitting in the back of the courtroom, Joe McCullough, he represents multiple jurors from Alex Murdaugh's original double murder trial. He notably spearheaded legal efforts accusing the South Carolina State Law Enforcement Division, SLED, of ignoring documented jury tampering. Jury tampering advocacy. McCullough represents jurors at the center of the controversy surrounding former Colleton County Clerk of Court Becky Heel. He has actively pushed back against investigators regarding how the alleged tampering was handled. So there you go. That's who he is. All right, let's keep going.
Which I would not want to do to any county. Sometimes I go to really small counties, and I don't think it would be good hold a pretrial there. Does it suit?
I mean, from the state's perspective, and again, being a longtime AG, I've been in pretty much all of them. And as an AG, Lexington is like a second home, obviously.
Convenient.
Solicitor's office, law enforcement, the court, of course, is very accommodating here. So this is certainly, I think, would be of most convenience for parties as we get ready for
Okay, it's not far for anybody to travel. Mr. Harpootlian? Okay, then I will try to make sure that when we arrange these pretrials that we will try to be here in Lexington. Anything else, Mr. Waters?
I believe that's it from the state.
Defense?
That's all we have, but if we could talk about that schedule for the next pretrial.
Oh, I'm getting ready for it right now. Let me tell you what I have. I've gone through my calendar. And so it's hard to get lawyers together, especially when I have this many lawyers. So let me throw some dates out to you. August the 13th and the 14th. July 29th, the 30th, or the 31st.
So, in chronological order, the first would be
July 29th.
I'm scheduled to be out of state with that from the 29th to the 31st.
Okay, then let me move on to August 13th and 14th.
Your Honor, we have a mediation on the 13th. The 14th is available. Yes.
14th works for the state, John.
August the 14th it is. That will be our next pretrial. Now,
Bless it. Look at the poop. Still scrolling his phone. Jim Griffin is like, we're fine. It's fine for the 14th. But here comes Mr. Harpootlian. He's still scrolling, bless his heart.
with that said, I'd like to have all motions by August the 7th, if I could. I like to read my motions. I like to be prepared. So if I could have your motions I understand that some of them are late. You might think of something at the last minute, that's fine, but please don't file something at 10 o'clock at night and expect me to rule on it in the morning. Okay?
I apologize for those coming in late.
No, you're fine.
I came into the office just to make sure we had something out there.
Mr. Waters, you're fine. I was not planning on ruling on those motions. Now, had I been, I might say something different. But please don't do that to me, okay? Now, let's talk about a trial date. The only other information I would like to know is how long this DNA is going to take. I would like to know that, but I'm going to tell y'all, I'm thinking April the 5th. And this being, I'm trying to get through Easter, and I know how hard it is to pick a jury when you've got spring break. That's usually right before Easter. It is the March. Is it the 28th? I think it's just the week. It's March 28th. So I'm thinking April 5th. I know that we'll have a new attorney general coming in. Mr. Harpootlian has already told me it's going to take 6 months to get experts prepared and ready to go. That would give the new attorney general time to look at his case in case he's going to be here and join us. And let me tell you this, tell both of y'all, I think y'all know me pretty well. When I set a trial date, I don't do continuances. I don't do it. It better be a really good reason. So, how does April the 5th sound, Mr. Waters?
Yes, ma'am. They'll be ready.
Mr. Harpootlian?
We'll be ready with some contingencies if the DNA takes longer, for instance, or
I will have that information by next pretrial. If I need to extend it out a couple of weeks, I will, if that's the case. Please do not think that this case is going to be tried a year later, because it's not. We're going forward.
Your Honor, we're more than happy with that. Mr. Murdaugh is more than happy with that. I just, again, really everything like, because the science in all these areas is much better than it was 5 years ago.
I understand technology.
Look here, Mr. Harpootlian, it's going to be April 5th, okay? And yes, the judge has already said, listen, if the results cannot be back, and okay, so they're wanting to start the trial, which means jury selection on April 5th, okay? And they would need time for the testing to be done and completed, the results furnished to the state, and the state would have to have somebody, an expert witness, to come in and analyze those results, all of those things, right? April 5th seems reasonable. She's willing to, push it out a little bit if she's got to because of that. But we don't have to harp on how much technology has advanced since 2021. But to be fair, yeah, it has advanced since 2021, but the trial happened in 2023.
Technology changes overnight. Overnight, I understand. Mr. Griffin, anything you'd like to add?
Yes, Your Honor. The Supreme Court reversed this case on
Oh, geez, shut up, Mr. Griffin. Jonah's mom, there are no stupid questions. Bindi, will you be covering this trial? Hell yeah. Hell yeah, I will. And I got to say, Letitia Stauch's trial was overturned. Her conviction was overturned before Murdaugh's. And we haven't heard a peep. Let me just see if there is any updates on Letitia Stauch. while I have all of you guys. No, that's the original. Nothing yet. So she got her retrial in April. Murdaugh got his in May. So yeah. Let's hear this last little bit of what Jim Griffin has to say, that I'm inclined to feel this way. Like, we already know, I don't know why you're even bringing this up, because this is kind of how I feel about it.
Oh my God, who the hell cares?
Like, I don't know why it was necessary for him to bring this up, but let's hear what he's got to say.
Overnight, I understand. Mr. Griffin, anything you'd like to add?
Yes, Your Honor. The Supreme Court reversed this case on misconduct by clerk of court, but the Supreme Court also addressed financial crimes evidence, and depending on how much of that or any of that comes in, will determine the length of the trial in many respects. Judge Newman last time would not rule pretrial on that issue.
Mr. Griffin, let me refresh your recollection. Part of the reason, the reason that more of the financial crimes evidence came into the murder trial was as a result of your cross-examination of a specific witness whose name escapes me. I can see her face, but I cannot remember her name at this moment. But it is you who opened that door even wider. But please, let's.
And it's going to be an issue that we're going to have to brief and argue with Your Honor as to, we don't think any of the financial crime evidence should come in at trial. And so I'm just flagging that it would be helpful to us, I believe, and to know if we're going to have to defend against that during the trial, or are they going to be able to put it up. And so I'm just asking maybe some earlier date where we can have, Your Honor, address those issues.
We will. I'm just going to tell you, I like to address all pretrial matters beforehand, because when I say April the 5th, we're picking a jury and going forward. All those issues should be decided by then.
Your Honor, that's my practice as well. We filed extensive pretrial motions prior to the prior trial. Laying all our cards on the table. It's exactly why we thought that was admissible.
Thank you. I appreciate it. Anything further before we adjourn, Mr. Waters and Mr. Harpootlian?
Nothing.
All right, perfect. Have a good evening.
All right. I wanted to see. I'm going to have to go through this. I wanted to see, he mentions that it might have been Jenny Nanette. I just cannot remember what her name is. But I'm going to go back and look at the actual ruling from the Supreme Court and what they said regarding the financial crimes. I don't want to do it on the fly, because I'm going to need to be able to read it first of all. Then I got to make sure that I understood what I read. And then if there's parts of that I don't understand, then I got to hit the Googles. And I'm not going to sit here and make you guys listen to the fan blowing in the background while I do all of that. I think that's not appropriate, or not appropriate, but I don't think that's fair to do to you guys. You guys already put up with enough of my BS, like my buffering and sometimes I get yelly and all the things. So, and I appreciate all that. So I'm not going to make you sit here and listen to the fan blowing in the background while I don't speak because I'm looking up stuff. All right. And so I'll do another live about all of that and see exactly what was said and what the ruling was, if anything, and if any of that evidence was ruled inadmissible. And I feel like my gut wants to say if it was ruled if there was evidence that was of the financial crimes that was let in, that the Supreme Court felt should not have been let in, and that the trial court erred in that, I feel like why would Griffin be asking that such an open-ended question? Because then he would be because the ruling would be in specifics. And if the trial court was determined by the Supreme Court to have erred in admitting admitting some specific evidence, then the question doesn't need asking, and also doesn't need an answer, because then why would the new trial court admit that evidence in? Does that make sense? Like it seems like it's a nonsensical, ridiculous, redundant ass question. So I'd like to see, and this is the thing. Ginny said, I think it said they aren't allowed to go through all of it, but not sure how much, if any. See, they didn't go through all of it. I mean, there was a bit of it that was left out, but part of the issue, as I recall from the trial, was there was something that Jim Griffin asked, and I want to say yes, that it was Nanette on cross-examination that then opened the door. And I remember this because the jury got dismissed. There was an in-camera hearing. We all watched it with the jury not being present, and there was argument back and forth, and ultimately Judge Newman allowed it in because of on a limited basis. Like they couldn't just say, they couldn't just ask, about everything, but there was some of it something got to come in that wasn't previously going to be admitted because of the question asked on cross-examination. But I'm going to look into it because we've got hearings. We've got another hearing August 14th, which I will cover. So, yeah. Anyway, I want to thank everybody for being here today. If you have not done so already, please give your girl a thumbs up on the live. And if you are listening on the replay, would you do me a favor and give me a thumbs up and hype the video? I would greatly, greatly appreciate it. I hope you guys have a fantastic rest of your day. I am tentatively, I have to work out some details, potentially going live tonight around 8 Central, maybe 9 Central. I don't want to say too much because I need to, there's some, for lack of a better word, some balls are still in the air, as it were, but be on the lookout for that. What I'll do is, obviously, if I end up going live, I'm going to schedule it at least 2 hours in advance, but I'll also share it on my community tab so that, you guys get notified. Yeah, tonight, Becky. But anyway, we have a pretrial hearing scheduled in this case for August 14th. I'll cover that, of course. Also, coming up, I know that there are other trials. The two that are right next to each other is the Lindsay Clancy trial, and she's the one who murdered her children and then jumped out of a window trying to delete herself. And then there's also the attempted murder and contraband charge that Austin Drummond is being tried for, and they both take place around July 20th. And so, whichever one seats the jury first is the trial that we'll cover first live, and then whoever seats their jury second is the trial we will obviously cover. Will be behind. But I feel like there's something else that's coming in July, like maybe at the beginning of July, but I can't remember off the top of my head right now. So we'll play it by ear. All right. Also, there will be more West Memphis 3 content on the second channel, so be on the lookout for that and in Patreon. I just wanted to also mention that when we were talking earlier about the books that Terry Hobbs and John Mark Byers wrote, I read the books, the book written by Terry Hobbs in Patreon. So if you're interested in that, go check that out. And I think that's everything. Let me just drop the Patreon link right quick so that you guys, if you are interested in that, you can go check that out. I'd love to have you join as a member. And I think that's everything. Yes, as Neat Noodle said, keep track of your balls, everyone. It's very important. Hey, Lisa, good to see you. I guess I'm going to let you guys go. Maybe I'll see you tonight. If not tonight, then soon. All right. You guys have a great rest of your afternoon, and I'll talk to y'all later. All right. Bye.